Hi, good afternoon, everybody. Please keep your audio on mute and do not switch on your video. We'll just start in a moment. Thank you for joining us at this webinar entitled Important Elements of a Will. If you're having lunch while listening to us, enjoy your lunch and also enjoy our webinar. And for those of us who may have already been out having our favorite supper early this morning, is really something. Eating out is something which I never imagined. And I've taken this for so long and taken it for granted.
Oh yeah, up to you.
Yeah, so thank you. So we have this afternoon Mr. Andrew Wong. He's an associate with our company, Fortis Law Corporation, an advocate and solicitor of the Supreme Court of Singapore. His areas of practice include criminal law, family law, elder law, estate planning, and advanced care planning. So we have the next slide, please, Yeling. Just to give you a sense, we look at our services, very simply divided into two big groups, the private client practice group, as well as the corporate client practice group. And underneath that is also our contact, two offices, one's in Raffles Place, Clifford Center, and the other is in CPF Jurong Building. Right, so without further ado, I'll just hand this over to Andrew. If you do have any questions, please just type them in the chat group, and we'll do our best to answer as many questions as possible. Over to you, Andrew. Thank you.
Hi, thank you, Jacqueline. Hi, my name is Andrew. So today we'll be doing the presentation on whales. So without further ado, I will share screen for my slides. Okay, share screen for my slides. Okay, so if everybody can hear me, could you type 1 in the group chat? Just type 1 to let me know that you all can hear me. Okay. Okay, thank you everyone. Okay, so now I will move on to talk about today's topic, important elements of a will. So I will take questions at the end because it's so just to keep the flow of the presentation. Later, you got any questions, just type in the group chat or on the Facebook Live. You can type on the Facebook Live too, and we will answer questions at appropriate junctures. Okay. So I just ask that everyone keep yourself on mute so that I can be heard more easily. Thank you. Okay, so today's topic will be about wills. We'll do an introduction to wills, and we also discuss the appointment of executors and the roles and responsibilities of an executor under a will, appointment of testamentary guardians, and of course distribution of assets pursuant to a will. So fairly simple flow of the webinar today. So without further ado, I'll just start to introduce you all to a bit about what a will is. So basically, what is a will? A will is a written legal document, as we would probably know. It's to govern the distribution of your assets after your demise, your death, okay? So a will, one thing to know about will is it's ambulatory in nature. It speaks from the date of your death, meaning that, let's say you pass away on this date, then as of this date, what assets you have, then that will be distributed in accordance to the terms of your will, okay? So a will is ambulatory in nature. Yep. So there's just some formalities under the Wills Act which I will go through. So the testator needs to be at least 21 years of age. So a will must be signed in the presence of 2 witnesses present at the same time. Okay, so this is an important point. We get a lot of questions. Oh, can you video conferencing witness a will? You know, we do get queries like that. But actually, there's no definitive case law to state whether wills can be witnessed via video conferencing, to be honest. So actually, we want to say that the prudent approach is, of course, to execute wills in person. Okay. And another thing, gifts to an attesting witness or the witness spouse is also invalid. Okay. So these are just some formalities under the Wills Act, which are these are like Will 101 basics under the Wills Act. Okay. Yep. So these are just some pointers to note. So okay, under a will, you will appoint what we call an executor. So when you pass away, in Singapore law, your assets do not automatically go to your heirs or your basically your descendants. Okay, this is unlike other countries like, for example, Taiwan, where the assets will just go to the beneficiaries directly. In Singapore, there actually is this office of an executor. The executor will be the person who will be in charge of gathering your assets and then distributing it to individuals, okay, to the beneficiaries, okay. So one of the key features of a will is the appointment of an executor who would administer your estate after your death. So the executor can be a loved one or professional executor like a law firm or a licensed trust company, okay? So these are just some of the uh, crucial points of an executor. So what must an executor do? So after your death, your executor will apply for the grant of probate. Basically, it's a court order, okay, simply put. So if the estate is less than Singapore 3 millions, you would apply to the Family Court of Singapore. If the estate is more than 3 million, you would apply to the High Court Family Division for a grant of probate. Okay, so depending on the size of the estate, the grant of probate can be obtained anywhere within 2 to 6 months. Yep. So depending, of course, you have more assets, then the lawyers will take more time to write to the banks to gather the assets. So basically, with what we do in the application for grant of probate is that the lawyers will write to various banks on the executor's instructions. Let's say you have 5 banks, 10 banks, we'll write to them. Then the banks will take some time, a few weeks maybe, to get back to us. So they'll give us a letter, say, oh, condolences, on the date of death, the testator had these bank accounts in this bank and things like that, okay? So if you have assets, the more massive your estate, naturally, the more time taken to apply for the grant of probate. Okay, so ballpark, smaller estates, 1 to 2 months, we can get a grant of probate. Bigger estates, I have seen before, 6 months and beyond, it's also possible. Okay, so of course, the first duty of the executor is to bring the original will, bring the original death certificate to the law firm, and apply for the grant of probate. Yeah. So the grant of probate is basically a court order that allows the executor, once it's granted, to distribute, to have the power to deal with the assets and distribute it. Yeah. So as I mentioned, the executor will have to call in the estates belonging to the assets belonging to the estate. So he or she will open an estate bank account and then or an estate securities account. This is example your SGX CDP to open an estate CDP account. Estate bank account, let's say you can go to a bank, example DBS, you open an estate account, then all the bank accounts the deceased had, you transfer all the money out, transfer into this consolidated central estate bank account. Then from this estate bank account, you can then disperse the monies to the beneficiaries accordingly, as per the terms of the will, of course. Then also for, let's say you have real estate properties, you can file for the transmission of properties to the executor to enable the executor to sell or to transfer to the onward to the beneficiaries, again depending on the terms of the will. So sometimes the will might say sell the property, so you sell the property and distribute the sale proceeds. Sometimes the will may say, no, I want to give this house to my son, then the executor, you give the house to the son. A lot depends on how the will is drafted actually. Yeah. So you have to call in the assets belonging to the estate. This is another of the executor's job. So regarding the distribution of assets, the executor always has a duty to provide estate accounts upon request by the beneficiaries. So everything the executor do must be above board. Basically, the executor cannot just take the money and run away. That should be obvious enough. Yeah, the executor has a duty to provide estate-related information and accounts to the beneficiaries upon request. Then the distribution of assets must, of course, be in accordance with the will. So if the will says 30% to my son, it means 30% to my son. And 50% to my wife, it must be 50% to my wife. 25% to my husband means 25% to my husband. Executor's job is to follow the terms of the will, because the will is what the deceased wanted. So the executor needs to follow that arrangement, okay? Now, there is this option for beneficiaries to execute what we call a deed of family arrangement if they wish to mutually rearrange their rights. This will, of course, be a deviation from the terms of the will. So how it could work will be, let's say, I give my son the house, I give my daughter $1 million, but then they want to swap. My daughter say, I don't want the 1 million, I want the house. Even let's say the house is also worth 1 million, but the daughter wants the house, she don't want money. Let's say they can mutually sign what we call a deed of family arrangement to rearrange their rights if they want to depart from the terms of the will. But for this option, all beneficiaries need to sign. Okay, so it's of course not an ideal situation. Best is if the will was followed, then the executor just followed the terms of the will. If the beneficiaries want the executor to deviate from the terms of the will, then everyone can do what we call a deed of family arrangement. So our law firm also offers such services for beneficiaries to consider. Yeah. So under a will, so another point to note, given all these duties of an executor, it's of course important that you appoint someone you trust. You appoint a loved one to do it for you. If you're afraid, oh, what if my loved one take my money and run away? I don't trust my loved one. Okay, number one, if you don't trust him, don't appoint him as executor. I think it's as simple as that. Number two, you trust him, but you want an extra safeguard. You can always choose to appoint two executors, for example, joint executors. So two executors have to sign all the bank documents together. So this will be more cumbersome for them because they have to coordinate their schedules to go to the banks together. But the benefit is you can be you can be rest assured this is like an extra safeguard to ensure that the executor don't go rogue. You see, so there are many permutations. People always ask me, what if the executor do something wrong? Of course I'll say if executor do something wrong, beneficiaries can sue the executor. But then that is more cure, right? So prevention is better than cure. If you don't even want to get to the cure stage, for prevention, number one, appoint someone you trust. Number two, you can appoint more than one person to check and balance each other. That's also possible. But of course, you have to weigh it against the fact that it's more troublesome for the executors if there are multiple executors. Yeah. So you can also appoint what we call a testamentary guardian. So basically, a testamentary guardian is someone you appoint under your will to step into your shoes, to have care and control of your minor children below 21. So Section 7 of the Guardianship of Infants Act, the testamentary guardian will act jointly with the living father or mother as the case may be, unless the living father or mother objects. In which case, if there's an objection that cannot be resolved amicably, you might have to go to court to settle the dispute. Okay? Then you probably have to settle it at a family court if there's no amicable resolution. Then if you and your spouse both pass away having appointed different guardian, let's say father appoint his sister, then mother appoint her sister, the appointed guardians will act together to take care of the children. This is Section 7.5, the Guardianship of Infants Act. So you can appoint someone to take care of your children below 21. What we call the mechanism of a testamentary guardian. Okay. Okay, I'll just pause for a while. I see a question from Raymond. Difference between a will and a trust. Okay, so basically under your, you can build a trust into a will. That means you get one clause in the will to create what we call a testamentary trust. So how it works will be, let's say you don't want your children to get everything at the age of 21. You want to space it out, say 50% at age 25, then another 50% at age 35 when they're more mature. You can actually, there are ways to draft it. We do it on an almost daily basis. You can actually build it into your will such that your executor will only distribute the money at certain junctures in time. This is what we call a testamentary trust. We can build this into the will. Depending on your, usually this is done for children. Parents don't trust the children to handle money at too young an age, or they do it for maybe special needs children, people with disabilities who may not be able to handle money. Then you appoint the trustee, the executor and trustee to disperse money on, let's say, a monthly basis for living expenses. Also possible. We can do that also. Yeah. Okay. So going back to my slides. Okay. So the distribution of assets pursuant to a will. So what assets can you give away under a will? Condo, HDB, landed property. My HDB image never load. Okay, but never mind. You can give your properties away under a will. But one thing to note, when it comes to joint tenancies, jointly tenanted properties, you generally do not give it away under a will. A joint tenancy, the properties, what we call they have this thing called the right of survivorship. So it usually will devolve onto the joint holder, so the joint owner, so joint tenant. So what happens will be when a husband and wife, let's say they hold a property in joint tenancy, the husband pass away, the husband share disappears. The wife is entitled to the property 100%. in her, because that's the nature of the right of survivorship. So if you own property in sole name, or the other type of co-ownership we call tenancy in common, where you own a fixed percentage share of the property, you can give away your sole name property or your percentage share property under a will. That one you can do. For jointly tenanted properties, this will just go to the other joint owner. Your name will be taken off the title deed. Simple as that. Okay, or HDB flat appear the picture. You can also give away, these kind of things. These are what we call immovable properties lah. Your bank monies in bank account, your SGX shares, your valuables, jewelry, watches, Patek Philippe, Rolex, things like that. You can give away under your will also. Okay, so these are some things you can give away under a will. So what can you not give away under a will? Insurance policies with nominations made. So if for those of you who have life insurance, your death benefits, right? If you make a nomination, I myself have, like when I buy my Prudential policy, I just sign the nomination. Nomination, when you make a nomination, it will go to your benefit. Your beneficiary just needs to contact the insurer. The insurer will pay them directly. So this will bypass the probate process I mentioned earlier, okay, for insurance. CPF also cannot give away under a will. Please make a CPF nomination. The CPF money will be distributed in accordance with the nomination. Properties held in joint tenancies, I explained earlier. So if you own property in joint tenancy, your share will just disappear after you die. The other joint owner will get the property. Okay, joint bank accounts. This one is a tricky topic, okay, because generally speaking, there's a right of survivorship in joint bank accounts, but there are cases where people dispute, say, oh, the money in the joint account is not meant to go to the other account holder, it's meant to go into the will. So you see, it affects, let's say you have a big sum of money in a joint account with me. Then has the joint account holder, of course, I want the money. But let's say under the will, I'm only, let's say, a 20% beneficiary. It's a matter of whether I get all the money in the joint accounts in accordance to the right of survivorship. But if let's say the money suddenly falls under the will, I may only get my percentage share under the will, depending on the terms of the will, you see. So actually, joint bank, we always advise clients, try not to put so much money into joint accounts, because we do a lot of cases where people dispute the ownership of joint accounts. So we actually we say you can have a running account, maybe some joint accounts, some money inside just for expenses. But generally, if you want your money to go to beneficiaries, you should always park it in your sole account. Then instead of that, from there you can say, oh, I give from all my assets, I give how many percent to each beneficiary. Joint accounts tendon that there's a chance for disputes. It's not, I wouldn't say it's very common, but it's not unheard of also. So joint accounts always tricky. We always advise clients try not to put money in joint accounts because it leads to a lot of complications later on. Okay, so that's something to take note of. So basically, these are just to share a bit. So when you pass away, the probate is obtained. We will compile what we call a schedule of assets for you. For your estate, so the executor will know what assets you have by the time you pass away. Then the executor can call in all these assets, and then these assets can then be onward distributed to the beneficiaries. So that's in a nutshell, that's really what a will is, and we also tie in nicely to what the executor's job is supposed to be lah. Okay. So I see a question. How about joint SGX account? Then this one joint account will go. Generally speaking, it will go to the joint account holder. That's the nature of how joint assets work. Of course, subject to my caveat that joint accounts, there's a chance it could be disputed lah. Okay. Can we change the nomination under insurance policy? Okay, this depends on whether the insurance is whether you make a revocable or irrevocable nomination. If you make irrevocable nomination, what we call a trust nomination, you cannot change it. It's not yours anymore. For a revocable nomination, you can change it anytime you want. Just need to inform your insurer. So those of you who have insurance, if you can't remember whether you make nomination, you just check with your insurance agent, your financial consultant. They would definitely know whether you make a nomination or not. Then from there you can decide. Today you nominate your brother, then 10 years time you change your mind, you nominate someone else. You can do that. Yeah. Okay. So this is just, I'll just go to the next slide first lah. This is some of our contact details, but now we can do some questions lah. Today's webinar is very free for all. Any questions relating to wills and probate, I'll be happy to try my best to answer your questions lah. Will insurance policy nomination override a will? No, your insurance policy, yes, your nomination will not fall part of your will. So basically, what you nominate is already what you nominate. Is not part of your entire estate. So normally your will will distribute the will might rephrase something like I give my entire estate to the beneficiaries in the following proportions. But entire estate is what is in the estate ma. If you nominate already, that's not part of your estate anymore. It will go, the insurer will directly pay out to the beneficiary. Yeah. So anybody got any questions can feel free to ask. How do I indicate the shares of a private company? You can indicate. So let's say I own shares in for private companies a bit different from public company lah. So this one you all can say I ABC Private Limited. You are a shareholder. You want to give the shares to someone. You can put in your will. Then the beneficiary will take over the shares of the company lah. Then they are able to become the shareholder thereafter. Of course, this one, the exact mechanism of transmitting shares, we may have to liaise with your company, the corporate secretary, the share certificate, all that they have to issue. It also depends on the company constitution, things like that. This is more corporate secretarial in nature. But in terms of the will, no problem. You can include it in your will. Yeah. Okay, I see. After probate is issued by the court, what will happen if the executor passes away before the assets are distributed? Okay, then someone else have to step in, has to do the role. You have to apply to court to depends. Normally we will have, I do some cases before the will got two executors, but one died. Then if one died, the other one continue lah. But if it's a sole executor, then someone else might need to apply to administer the assets. There are procedures for that. Okay, Alice has a question. How does an executor refuse to be appointed as an executor? Or you can just refuse to, because the executor is the one that needs to apply to court to be the executor ma. So let's say you are the executor, you've been appointed as an executor. After the death, you will bring the will and the death cert to the law firm and you apply for the grant of probate law. But what you're saying is, what if you don't want to do? Then you always have the option of renouncing. So you renounce, you say, I don't want to be the executor. So the consequence of this will be another of the beneficiaries can step forward to apply to be the administrator of the estate. Different. Executor administrator because he or she was not appointed under the will. So the administrator will then apply the one of the benefit. Assuming executors renounce, refuse to be appointed, then there's no. Let's assume the will don't have a backup executor. Normally, we also put a backup executor into the will. The consequence of this will be the beneficiaries. One of them can apply to court to be the. This will be a procedure what we call letters of administration with will annexed. So the will still govern the distribution, but in terms of the person distributing, someone has to step forward to be the administrator. Yeah. Okay, what will happen if you do not have a will? This will go under the Intestate Succession Act. So the percentages are fixed by law under the Intestate Succession Act. If you have a spouse and children, spouse will get half, children will get the other half. You have no children, but you got living parents, spouse get half, parents get the other half, and so on and so forth. There is a order of succession in the Intestate Succession Act. So that one is just the percentages are fixed by law to answer your question. Yeah. Okay. Katrina has a question. Nowhere will all money go to the next joint account holder in the joint bank account. I mean, like I said, the joint account is separate from a will, technically speaking. Joint account holder is supposed to go to the surviving account holder, subject to, of course, someone might claim that, oh, the deceased was the one that pumped in all the money. The living account holder never pumped in money, then they dispute. But I mean, putting disputes aside, yes, it goes to the surviving joint account holder. Okay. Can you change joint tenancy to tenancy in common? Yes, you can. You can do what we call a deed of severance. You can sever the joint tenancy to a tenancy in common. That one is fairly administrative, can be done. Law firms offer this service. Okay. Can a benefit? So if joint tenancy, you sever it, you become 50-50 tenancy in common, just to inform you. Okay. So there's a question from Lee Teng. Can a beneficiary of the shares of a private company be someone less than 21 years of age? Okay, again, Number one, you need to check your company constitution, who may be a shareholder, but generally speaking, or you can also ask generally speaking, the trustee, the executor can hold things on trust for the minor beneficiary until he or she turns 21 years of age. That's quite common in will. Normally, the wills we don't give to children below 21. We ask the executor to hold for them until they turn 21. Yeah. Okay. Assets left behind without a will and without any LOA applied, so no letters of administration applied for by beneficiaries like CPF, shares and jewelry, any time bar to apply LOA, not that I'm aware of. Generally you can apply for administration if, I mean, there are cases where nobody apply for very long, then suddenly apply, it happens, but try not to lah. There might be a lot of questions asked. It's just when you know someone passed away, just go and apply for the grant lah. Yeah, okay. Then if Wong Amy to everyone, if both owners pass away same time, how can the HDB distribute? Then okay, so this one, this is a tricky situation. Children below 21, but let's say father mother pass away, so father mother both die, right? So let's assume the will is to go to the children lah. The HDB goes to the children, but children below 21, we know HDB rules. You cannot own HDB if you're below 21. This one we know, okay? So what will happen is there's a chance that the HDB flat might have to be sold, then the money will still go to the children. Because for HDB, right, when you're giving HDB, a lot of it, whether the beneficiaries can keep the HDB flat is always subject to HDB approval. HDB have their own eligibility requirements. So like we all know, like if you're single, you must be above 35, then you can own HDB. There are rules like that, or if you're adult, you must be married, then you can own HDB. There's a lot of permutations to this. So a lot of time HDB does this case by case basis when you apply. But if they're below 21, there is a chance that if HDB they're not eligible to keep the HDB, then you have to sell it. Sell, of course, the money still goes to the children, but so you see, the HDB is still theirs technically, just that they can't keep it. So they can't keep it. The consequence is sell and get money. I mean, money can buy things, right? Can buy house, Okay, then the executors are usually not paid a fee. Can the will state a fee for executors? Basically, the no you executor can be beneficiary too. So like your wife can be executor plus beneficiary. It's actually very common for a beneficiary to be an executor too. So we always advise client try to give the execute try to let the executor be a beneficiary too, so that the beneficiary so that the executor, like you say, he doesn't sit on it and not distribute and take his time to distribute, because if he's a beneficiary, he's also kanchiong to get the money so he will naturally put in effort to go and administer the estate properly. So we try and appoint executors who have a share of the estate too. The will also is not so much a fee for the executor. You can state a fee, but normally what you can do is you ensure that the executor himself or herself is a beneficiary of the will too lah. Of course, if you appoint professionals as your executor, let's say you appoint lawyer or trust company, then they have their professional fees. The one they will charge you for doing the executorship lah. Okay, Sandy has a question. What happens if beneficiary pass away? Usually we usually have a pre-deceased clause in our will. So we say like if any of the beneficiary pass away, his share will go to the other beneficiaries in the will, for example. That one is a matter of how we draft it in the will, not a problem. It's quite common to do it in that way. Okay. Then Chris Day has a question. Can a trust be in a form of an annuity to siblings and payment when they reach it? You can. This is what I was saying earlier, testamentary trust. So you say like, oh, I pay X dollars a year up to this year from my assets. Of course, depending on how much assets you have, then it can be structured that way. We can draft it into the will, not a problem. Okay, for Susie Tay has a question. For dementia elderly, family does not know if CPF nomination done. If nomination, CPF will automatically write you a letter. No action needed. CPF will contact the nominee directly. If no nomination, simple. CPF will distribute it in accordance to the intestate law. Remember I mentioned the one that if you die without a will, that govern. If there's no nomination, you will follow the intestate law. So like spouse half, children the other half, depending on who the next of kin are lah. Okay, so that's how CPF will distribute it. Is there any difference between executor and administrator in terms of function apart from the designation? Not really. The duties are the same. They just have to. The only difference is that executor is appointed by the deceased, administrator is appointed by the court. That's the difference. So administrator, there might be a bit more onerous terms. For example, if you are the administrator of an estate, let's say there's a few criteria. If I'm not wrong, if it's worth more than 5 million, it's either 3 million or 5 million, I can't remember offhand, or you have beneficiaries below 21, or you have a mentally incapacitated beneficiary. In these cases, the administrator might be required to furnish security, like surety. You need to find sureties to stand surety for the administrator. This is for administrator lah. For executor, there is no such requirement. Executor, because the legally the rationale is that this was appointed by the deceased himself, so there's no need for further safeguards. So executor's job is usually easier lah. Administrator, depending on the estate, there might be extra conditions like having to find sureties for the court to satisfy the court and things like that. So that's a key difference. Of course, if the administrator the estate is not big, there are no minors, no mentally ill people, then the difference might be slim in those cases. But the difference becomes bigger in those situations where I mentioned. Okay. Okay, there's a question. Wait, okay, I answered that. Okay, so if a will is done long ago, how does one retrieve it and forget the lawyer who did it for them? Okay, well, you can try and check the wills registry to see where the will is kept. But just to inform you, it's not compulsory to register your wills with the wills registry. If the will was done but not registered and nobody knows where the will is, then tricky lah, then a bit tough. There is this thing called information on wills where law firm can blast through the law society mailer. We can blast to all law firm in Singapore. Anybody got information on will on this person? But I can tell you, the kind of email is the kind of mess sent one. A lot of people don't read one. So it's tricky lah. I mean, it's not impossible, but there'll be difficulties in locating the will. If you can't find the will, then how do we apply for grant of probate, right? Yeah, that's a practical issue. Yeah. Okay. So there are two executors named at the point of drawing up the will. Yep, this is quite normal in case one dies first. Can one executor be able to execute the will, have access? No, you need, if there are two executors and they're both competent and one never renounced, right? They both need to be present to execute the will and go to the bank and do the signing of the checks and things like that. If let's say one executor don't want to do for whatever reason, or health not good, I don't want to do all this administrative stuff running around, you can renounce. So let's say you're alive but you don't want to do, you can always have the option of renouncing. Let the other person do. In fact, we have one case we did in my firm where one of the executors actually migrated to New Zealand while the other one still lives in Singapore. So the one that go New Zealand, clearly she don't want to do all this. She just signed a renunciation. So let the other executor handle the estate. It's quite common. Nothing too out of the ordinary. How long does probate or administration take to be out? As I mentioned in my slides, smaller estates can be 1 to 2 months, bigger estates can be 6 months or more. It really depends on how big your estate is and how many assets do I have to investigate on your behalf. Yeah. To minimize dispute, can spell out the distribution of joint accounts in the will. Yes, we can. I mean, there's possible clauses like, for the avoidance of doubt, I declare that all my joint account monies go to the joint account holder, or really just don't put money in joint account. I mean, we always say you just put a basic nominal amount just to handle household expenses, but your life savings, put in your sole name account. It's always safer that way. Yeah. Okay. There's a question here. A has a joint bank account with B, but B does not have a joint account. How? I don't understand this question. If you have a joint account, A has a joint account with B means A and B, they are both the owners of the joint account. How can B not have a joint account? Yeah, I don't quite understand this question. Okay, never mind, I'll go on first. Then can you include overseas properties in the will? Our company policy is we do one will per jurisdiction you have assets in. Reason being, I cannot guarantee you a Singapore will can be used in an overseas country because the different country have different laws on wills. So if you have assets in different jurisdictions, we always do one will per jurisdiction. So like a Singapore will for Singapore assets, Vietnam will for Vietnam assets, Indonesian will for Indonesian assets. Yeah, that's how we usually do it. Okay. Amy has a question. Children under 21 can't own HDB. Can the owners appoint trustees? Sorry, for HDB specifically, you cannot. You cannot create a trust over HDB. Condo, bungalow, all can. Specific to HDB Act prohibits you creating a trust over HDB flats. So unfortunately, that's not a workable option. Yeah. Okay. A lot of questions. Wait, I try. I see a lot of unread. I have this much time. I try my best to answer. Okay, then okay, those questions. Okay, some from 40's Law is from Facebook one. Okay, so is there a Facebook Live question? Is there a time limit on the grant of probate issue? What no there. Okay, if you apply for grant of probate after 6 months of death, you have to give you have to give reasons in the application. But this one normally no major issue lah. The reason could be, oh, I didn't know I have to apply grant of probate because I'm not a lawyer, that kind of thing. Like, you know, it's very common one lah. That's not nothing major. Complications without a will. Basically, you don't get to choose your executor, so your administrators, you know, let's say nobody want to do the job of distributing, or everybody, you know, let's say you got a lot of money, everybody want to fight to be administrator, also possible. So these are some complications that could arise if you have no will. How can all parents who are still alive will their joint tenancy HDB to the beneficiary? No, joint tenancy will not be under the will. I think I have to clarify. HDB, if you pass away, your flat goes to your other joint owner. It's as simple as that. Then of course later on he passed away, since the flat is already his, the person who passed away second, then the HDB will fall into the will. So it depends on who passed away first. Okay. Insurance policy bought by parent for children since young. Who is the beneficiary if parents pass away? Will that form part of the parents' estate? Bought by parent for children. I mean, it depends on whether there's the policy. If the policy holder is a child, then the policy is still alive, or just that they have to find a way to finance the policy lah. So I take it that the policy holder is the child, just that the parents are paying for the policy. So there's no that in that sense the policy is still live, or it's different for the person, the policy holder pass away, you see. But I have done wills before where the parents say, okay, from my assets, ask the executor continue paying for these policies that I bought for my children. I have written such wills before, so not a problem. That can be built into the will once again. Okay. Would the lawyer register our will at wills registry? Yes, for our firm at least we help you register. I can't speak for all law firm, but for our firm we will, if we do the will for you, we will help you register with wills registry. Okay. What is the cost for drafting a will? We start from 1,500 for our law firm lah. 1,500 upwards, because if you do directly my law firm, we charge you a higher price because it will be lawyer doing a will for you. Of course, we have a sister company called 40's Wills Private Limited. They offer more, so to speak, mass market wills, so the price will be cheaper, but that one won't be lawyer drafting lah. Because under Singapore law, there's no requirement that lawyer need to draft or witness will. This one, anybody, technically you can draft your own will, but it's obviously we advise you to seek either lawyer's help or professional will writing companies help lah. But legally speaking, nothing to stop you from drafting your own will. There's no rule that say only lawyer can draft will. Okay. If both executor based overseas, do they come back Singapore to execute the will? Unfortunately, yes, they have to, because they have to go to the even if they sign all the probate documents, they sign abroad, they sign at notary public or Singapore embassy, right? Ultimately, when the probate is out, they still need to come back to go to the banks, ma. So how long do they have to stay? I mean, I would say at least dedicate a few weeks here lah to go and so the documents, for the court documents, you can sign overseas, not a problem. But once the actual grant is out, you still need to come back to go to the bank, draw the money out, everything ma. How long you have to stay depends on how many assets there are lah. I can't give you a firm answer off the cuff. It depends on what assets. If you only one bank account, let's say only one DBS bank account, then very fast come back maybe 1 week done already lah. But it really depends on what the assets are, right? Okay. So the
Sorry, Andrew, just to interject. There's
yes,
like
go ahead.
23 more questions, quite a lot. So
yes.
don't feel too stressed. Just do your best to answer, because
yep.
we do also have to respect that there's a time limit as well.
Yep.
And really, so just do your best, okay? And for the rest of the unanswered questions, I'll just invite those of you who are on this webinar, look at the contact, take a picture of this contact, and do contact us to see how we can assist you. Okay, thanks, Andrew. Sorry, go ahead, please.
Yeah, of course, if any of you are interested in doing wills, please send us a consultation. I mean, send us, you can request for a consultation. We can set up a consultation with you and we can do your will. Yeah. The fees, we are transparent. I already told you we start from 1,500 lah for doing will. For grant of probate, we start from 2,500 plus for grant of probate. Yeah. So of course, once I better understand your situation, I can provide you a better fee code lah. Okay. So I'm moving along quickly. I'm trying to answer as many questions as I can. Okay. If default will go to spouse and children under law, why need to have will to indicate them as beneficiaries? I mean, I don't know your personal situation. Maybe one child is more filial to you. You want to give more to one child, or could also be, one child needs more financial support than the other. There are many reasons why the will people might want to deviate from or there are some people who want to give everything to spouse 100%, children zero. I mean, I think my own parents' will is each other 100%. That's also different from the default law. So they will do a will law. Yeah. So there's many reasons. I mean, I cannot give you definitively. Only you will know why you want to give how much to each beneficiary, right? Okay. Let's see. If both the tenants of HDB flat already fully paid for pass away together, can we mention in the will to leave the flat to other beneficiaries? You can, but again, subject to HDB rule whether the beneficiaries can keep lah. Let's say your children all grown up, all got their own flat, then chances is they can't retain the flat. Right? And similarly, if they below 21 also, they may not be able to retain the flat. You can will it to them. But if they can't keep, then the consequence is sell. Lor. I mean, sell the money, it doesn't just disappear. Right? You sell, the flat doesn't just disappear. You sell it, there is cash, right? The cash will go to the beneficiaries. So, of course, if HDB allows them to keep, then good for them. They can keep the flat. Lor. Again, for HDB, always tricky. Depends on HDB approval. Because HDB is such a unique creature, right? Unlike private property where you got more freedom to deal with it. Yep. Okay, then the A and B are co-executor. What can A do if he can't locate B? Then you can actually, I mean, if you can't locate, you can apply to what we call, there's this procedure called citation, where it basically says within X days, if B don't want to apply for probate, then we take it that B has renounced his right to probate, then A can proceed. Yeah. Okay. With the grant of probate, how soon there's a procedure for that, not to worry. If let's say somebody went missing, then with the grant of probate, how soon must the ownership of property? Of course, we'll do our best to try and locate the person. We call them, we send people to track their address down and things like that. Okay. With the grant of probate, how soon must the ownership of property be transferred? Usually, depending on the will will tend to give the executor discretion to postpone sale or to postpone sale. Let's say you're selling property, so you can wait for a good time to sell. For transferring, there's no fixed timeline, but it's always what we call reasonable period. If it's just like giving the person the property, you wait for a reasonable time to give the property. Shouldn't be that long. Okay. Then as an executor, how do I consider my duty is completed or discharged once I complete all I need to do? Once the estate is distributed, then the duties are discharged. Yeah. So basically, once you finish the grant of probate, you don't need to go back to court anymore. Yeah, there's no more court. Once I give you the grant of probate, generally speaking, you don't have to go back to court anymore. So you just ensure that so our law firm will help you apply for grant of probate. With the grant of probate, you close all the bank account, take all the money out, and you distribute. You have to keep estate accounts that like, oh, I give this person how much in. You have to justify the ins and outs of the. You just have an Excel spreadsheet or something to track the accounts Yeah. Estate bank account is open in the name of the deceased. So it'll be like estate of Tan Ah Kao, deceased, something like that. Is there a fee if we check the wills registry to ensure? I think there's a fee. Is it $5 or $10? I can't remember offhand, but it's a nominal fee. I think you have to log in with your SingPass to check or something like that. Yep. Okay. Then I see this question from Katrina. How to check if LPA is signed by someone? LPA can be given to more than one person. You can appoint donees under your LPA. So like, if you do an LPA form 1, it's 2 donees, 1 replacement donee. How can one contest if LPA is given to a sibling without other siblings' knowledge? I mean, you want to contest on what grounds? You have to, unless you think that the donor lost mental capacity. But I mean, that one, it depends on the evidence. There's no requirement to say LPA. Like if let's say mother want to appoint son has donee, right, there is actually no legal requirement for a mother to inform all her children to say, hey, I appointing big sister to be the donee. There's no requirement. She can choose. It's her. She's her fully entitled to appoint who she wants to without giving prior notice to anyone else. Although for our firm, when we do LPA, we will advise the donor to let all the children know. Let's say you got a few children, you only appoint one or two. I will advise them to let them know to prevent this kind of unhappy people. You just want to prevent people from being unhappy lah, correct? But I talk about actually contesting the LPA, you have to prove that the person had no mental capacity lah, which is not that easy to prove lah, because the certificate issuer, the lawyer or the doctor who signed the LPA is already a safeguard there. When the certificate issuer sign, he or she must be reasonably confident that the person who signed has mental capacity. So you have to go and, if you want to challenge, you will need some sort of strong evidence lah. Because don't forget, LPA is not something you sign yourself and submit. You have to go through. There's a gatekeeper, which is either a psychiatrist, a doctor that's accredited by Office of Public Guardian, or a lawyer. So these are all professionals. So there's a professional gatekeeper. When you come to do LPA at me, I don't just sign. I have to ensure that you are okay. You talk to me, I converse with you, you're okay. Then I sign your LPA. I mean, at least that's how I do it lah. So it's not as simple to say that, yeah, okay, can the executor appoint a POA to act on his behalf? No, the executor needs to, you need to act in person, generally speaking. Yes. Okay. Because there's a deceased property need to be transferred to an executor before it can be. So yes, there's this procedure called transmission of property. Okay. So we transmit the property to the executor, and then the executor will thereafter sell it. You need to undergo this procedure called transmission. It's a fairly administrative, convincing procedure. Maybe cost you a few $100 legal fees to do it. It's not particularly difficult to do. Yeah. Yeah. So I hope
Okay.
I'm
Yeah. I think any more questions? Andrew, I think just a point for us, like
yeah.
if you could just summarize, maybe, let's say before actually anyone wants to have a will prepared, what would you say would be the 4 key elements or 5 key elements that they must think about before they actually go and come to us to do a will? What would you say would be the 4 key things that they have to think about, before they come, let's say they contact us to make an appointment to have a will done? So you would think about the executor, right, for example?
Yes, think of the executor, think of who your beneficiaries are, the percentages, and also you need to basically have this information in mind, and then decide which assets you want to give to who, things like that. I think
Okay.
it's just have this information on hand and come to us, and we can take it from there. We have a more in-depth discussion when you come lah. Yeah.
Right, thank you. And also I think it'll be good to also keep, I think, a current list of all the assets that you have, like the different bank accounts and so on and so forth as well, right? And to review that and to update that from time to time.
Also depends lah, because
Yeah.
some wills are drafted generally. All my assets split in percentages. The rationale for this is people don't want to change their will every time they have a new asset, you see. So of course there are some old, maybe more for older people where they don't think they'll change their assets much already. Then they'll start listing specifically like, okay, this bank account to A, this bank account to B, this house to C, this car to D, things like that. But if you are middle age, younger, you can do a general will because your assets are so fluid, they may change. I mean, practically speaking, you don't want to be changing your will every 1 year, right? Maybe you change it every 5 to 10 years. That's a more appropriate kind of time frame lah. Yeah. So, but it's just, I mean, if you are intending to do a will with very specific gifts, then you can do a list of all your assets. Otherwise, it's still good to know, but your will can be drafted more generally. But
Yeah,
I
yeah.
mean, whether we draft it generally or specifically, Jacqueline is right to say that it's good to let us know what assets you have, then we can see how to work around it lah. Yeah.
Yeah, I think what I meant was really, of course, a will that contains the general clauses, but I think it's just as an information for ourselves, it's not part of the will per se, but to keep that like a little sheet, a little updated sheet as to what we have. So when the time comes, for example, I think for our loved ones who are aware of this will, and they'll know where to look for to go to which bank and all that stuff. Yeah,
You can
this
pass
is what
this
I
sheet,
meant. Yeah,
pass this sheet to your executor, or you can put it
yeah.
in the same envelope as your will, lor, also can.
Okay.
Yeah.
All right. Thank you so much, Andrew, for this very informative session. And thank you, all of you, for making the time to be with us, to spend this time with us. As always, do like.
Thank you, Jason. Jason
Yeah.
say Fortis is the best. Thanks, Jason.
Thanks, Jason. Thank you so much. And really do continue to follow and like us on Facebook and LinkedIn. Reason being is really because we have lots of these webinars that we do update. So when you do follow and like us on Facebook and LinkedIn, you'll be updated as to what's happening. And also, we also do have actually a YouTube page where we continually update with videos, very short videos, and these are on different topics that we cover, really for your information and knowledge. So once again, thank you everybody. Thanks Andrew once again, and have a lovely weekend. Keep safe, everybody.
See
Thank you.
you.
Thank you.